The next case is In Re LM. The appellee has waived oral argument. We have the appellant here for oral argument. You will have 15 minutes to present your argument. The argument is being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument. You may refer to them by initials or terms like the child. We have read the briefs and are prepared to proceed when you are.
Thank you, Your Honors. Good morning. May it please the Court. Joseph Schell from Summit Legal Defenders on behalf of LM, the juvenile appellant here. So this case is about what it means for something to be the direct and proximate cause of the criminal conduct underlying a specific conviction. Our position here is not anti-recovery for victims. There are lots of ways. Restitution is just one of them that people can get recovery for things that are damaged during the commission of a crime. A civil action is one. Depending on the type of crime, the Crime Victims Fund through the Ohio Attorney General is another. And we're not opposed to recovery via those avenues. We're not opposed to recovery via restitution in the abstract. But what this position is really is that when the government makes certain choices about what charges to pursue and make certain choices about amending those charges and what to include with that amendment and whether to make some sort of explicit agreement with the defendant or not, as in the case here, that those decisions affect what's available for restitution. And when the state makes the decision to charge only receiving stolen property, particularly based on the facts alleged here in the complaint, it is going to severely limit the amount of restitution that's available to the victim. And I think this case is really about the government being upfront and honest with the victims about that when it is a narrow charge like this.
So what is it about that charge that limits restitution?
Yeah, it's the direct and proximate, I think, connection and specifically how the Supreme Court of Ohio in State versus Yerke has described what that causation means is that the damage has to flow as a natural and continuous consequence from the specific conduct that underlies the charge. And that's why in the brief, we mentioned that it could be rare that in receiving stolen property cases, there is going to be damage that flows as a natural consequence from just the act of receiving it. There certainly could be cases. I can think of a couple examples, particularly because disposing is a way that you could be convicted of receiving stolen property.
So if you knowingly receive stolen property and then damage it, why would it be rare that you get restitution?
So that's a little bit different, I think, of it. So one, there's not an allegation necessarily in the complaint here that LM damaged anything. And second, that speaks to what I was talking about with the state making choices about what charges to pursue. If there is damage, that should warrant a criminal damaging charge or a vandalism charge or something like that. I was here 3 weeks ago talking about a criminal damaging case, right, where we had broken windows. That was the allegation for the criminal damaging. I think that's an easier direct and proximate cause case. But when you just have receiving stolen property, and this is the lesson from State versus Folsom, State versus Rohrbaugh, those other cases that we cited in the brief from the first and third districts, is that the restitution has to be focused on the specific conduct that the person is convicted of. So, to your point, Judge Lanzinger, all he was charged with here for receiving stolen property was being in possession of a car that he knew was stolen. There is no damage allegation in the complaint. He did not admit during his allocution to any damage to the car. And there were other people involved in this crime. There's actually, I think, an unknown suspect involved in even the theft of the car. And then there's several juveniles who were charged with receiving stolen property.
And I read the record as not being clear as to who the driver was of the vehicle. Is that
correct?
Is that fair? Okay.
That's right. Yeah. But LM was just charged with receiving stolen property. There are no criminal damaging charges, there are no vandalism charges, there's nothing that speaks to any action that would naturally, just as an inevitable consequence of committing that conduct, lead to the damage that restitution was ordered for here.
So when you say someone was driving a stolen car and wrecked it, they would be, without any other damage charge or anything else, would they be liable for restitution for the direct damage to the car and the rest?
Well, we'd certainly be having a different conversation if it was one person who was in the...
I agree, I'm asking if you have a view on that, and that's not the fact we have, I get that.
Yeah.
But
So,
from your argument to me saying, look, you charge receiving, but didn't charge damaging, therefore you can't get damages, it would seem logically to flow from that you would say, no, if they just charge receiving and I'm the driver of the car and I wreck it, well, you can't get restitution from you to that.
yeah, I think that's right. And I think that's what the First District held in State versus Folsom. That person was charged with, both receiving stolen property, it was I think bank robbery in that case, and breaking and entering because there was damage to the doors to get into the bank. That charge was eventually dismissed, but restitution was ordered for those broken doors, and the First District reversed and said no, because there's nothing from the receiving stolen property charge, which is the only thing that Folsom in that case was convicted of. There's no natural consequence. It's not a natural consequence of receiving stolen cash that you would damage the doors to get into the bank. And it's a similar situation, I think, in both that hypothetical situation and here. I think I would be in a tougher position if LM was the only person in this car. I think it would be in a tougher position if the police found the car closer to the time that it was stolen. There's a long period of time, 7 or 8 hours, in between when the car was reported stolen here and when the police found these juveniles in it.
Doesn't that logic defy all of our other criminal principles? So, like, if you have 3 offenders, you're all responsible in a complicity type of theory for anything that naturally flows from the offense. So if someone's murdered during a robbery, everyone's responsible. Wouldn't you also be responsible for the restitution in some form if you've received stolen property and it's damaged?
So again,
whether or not you're the one who damaged it or not, personally?
Well, we'd be having a different conversation if there were, if that were the case, or if there were a theft charge here, and there isn't. There are only
the prosecution has to cherry pick the charge to make sure that you can meet that natural consequences standard?
Well, it does have to make a decision, yes, about what it thinks it can prove. One, that's obviously one decision, right? What charges it thinks it can prove, and then on the back end, on restitution, yes, it has to make a decision about what it's going to charge and how that's going to affect restitution. What is a natural and continuous consequence from the conduct that I'm charging here? And when the government makes a decision to charge someone like it did here, LM, only receiving stolen property, only for riding in a car, that's the allocation, then that does limit, I think, pretty narrowly what is going to be available for restitution because of that, because you need that causal link, because there's got to be something about him.
Well, you say, I'm sorry, you say only riding in a car. He was charged with possession of this property. So conceivably he had possession of the car, not just a passenger passively sitting in the backseat. So I know they don't know what occurred, but the charge is possession of the stolen property. They were saying he possessed it, more so than just being a passive person in this car. It seemed to be from the charge.
Yeah, I think that's right. Maybe maybe this is a little hair splitting. I think, I think he's got at least constructive possession if he's in the car. And I think, right, in receiving stolen property, just, it does require possession with knowledge that it was stolen. He's in the car. He did say he knew 5 to 10 minutes after he got in it. A friend picked him up in the car. He got into it. 5 or 10 minutes later, he realized that it was stolen. How he realized that is unclear. There was damage to the ignition, damage to a back window.
And you mentioned splitting hairs. Out of curiosity for standard review, are you saying that this is a legal error or the court abused its discretion?
So I think, it's a bit of a close call here because I think we're saying because there's an error in the application of the restitution statute here, that's a de novo, that's a legal error, it's de novo review. And I think that is consistent with the appellate court's case law, is that when the statute's applied in a way that it's not designed to be applied, that's de novo review. And that is, I think, what we have here, right? Like, the damage has to be limited to what flows as a natural and continuous consequence from LM being in possession of a stolen car. And I don't think, there hasn't been an explanation really from anyone throughout the case how LM's being in possession of a stolen car somehow damaged the front fender, or the grille, or the bumper, or the gas tank, or anything else that was ordered for restitution, save for the tow. I think the cost of the tow is that flows, I think, from receiving stolen property. There's got to be a way for the person to get it back. That cost them something. That flowed as a direct consequence of LM's receiving the stolen property. But other damage to the car, he was not charged with that, and therefore he was not convicted of any damage to the car. And that, I think, is further evidence, Judge Stevenson, to your question about why this is also a de novo review, because it speaks to that statute being applied and restitution ordered for a crime he wasn't convicted of. And the cases that we've cited in the briefs that speak to that kind of a situation, those courts have applied de novo review in that situation. Right. So not only did the government choose here to charge only receiving stolen property, but it also chose to amend this charge from a 4th-degree felony to a 1st-degree misdemeanor, and to not include, as a term of that agreement, that some sort of restitution be paid. So there's nothing in the transcript that reflects that. There was no agreement. It was an amendment as part of the exchange was simply he would admit to it with the amendment down to a 1st-degree misdemeanor. The government certainly could have made a choice that said we will absolutely do that. Provided you agree to restitution in the same amount as the co-defendants. But it didn't do that. So that's choice number 2 here that limits the government's...
But it doesn't prohibit the trial court from having a restitution hearing based on Marx's law and determine if there was some restitution owed. It just means you had the right to argue we shouldn't be paying it and we're not responsible.
100%, yes. And the restitution hearing here was mandatory because we objected to any amount of restitution being ordered at the plea hearing. But right, we would have been precluded from doing that, and the government could have secured the restitution that it wanted had it made it an explicit term of the plea agreement. And it chose not to do that here. So it chose not to charge any damaging offense. It chose to charge
the record lay out why the prosecutor chose not to do that? Was there some discussion at the plea hearing? We're not doing restitution because we don't agree. Okay, fine, set it for here, I'll make a determination, the court said, or is it just not ever discussed at the plea hearing?
No, there's no explicit discussion like that. As far as restitution goes at the plea hearing, so the prosecution up top puts out the amendment, says we're going to amend this down. We understand it's going to be in exchange for him admitting to the 1st-degree misdemeanor. The trial court goes through, explains LM's rights, and then accepts the plea. And then on page 11 of the plea hearing transcript, that's when the state says, okay, here's what we want, right? We want him to, obey all the school and home rules, all that, and we're going to be seeking restitution in the amount of roughly $1,600. We object, and say that we object to, we understand that other defendants have stipulated to restitution. We're not doing that, so I guess we need to have a restitution hearing. So that's the extent of the restitution discussion at the plea hearing, but it was certainly not part of the agreement. The agreement, as it was set out up top, was just you'll admit to this if we amend it down to a 1st-degree misdemeanor. And so all of these decisions that the government made in this case narrow the path that's available for the trial court to order restitution. Again, I think it really just does come down to there's no damaging allegation here. There's only a receiving stolen property allegation. As the brief I think makes clear, there's little case law across the state really, and particularly in this district about what that natural consequence causation element looks like for receiving stolen property. But that burden is on the state or on the victim to show, at least by a preponderance of the evidence to the trial court, something that the specific conduct that LM was convicted of here, being in possession of a stolen car, that the natural consequence of that was the damage that they're asking for restitution for here. And because the record just contains nothing that links those things together, other than that it happened, which is the case law that we've cited in the briefs makes clear is not enough. The trial court erred in ordering restitution for that, and we would ask this court to vacate that restitution order.
Isn't the fact that the car was in a certain condition before it was stolen and it was in a certain condition after it was stolen enough evidence to meet that burden?
No, I think because it doesn't show that there's a natural consequence from the specific conduct that someone was convicted of. And I think, if you look at the first district's decision in Folsom, if you look at the third district's decision in Rohrbaugh, that's similar, right? In Folsom, criminal damaging charge for the defendant backing into the victim's car. The victim says, well, I parked my car on the street, it was fine. I hear a noise, I look out, and I see that she's backed into my car. Also, my tires are slashed and there's syrup in my gas tank. Trial court orders restitution for all of that. Damage to the bumper, damage to the gas tank, damage to the tires. And the first district reverses and says, no, what you were charged with and what you admitted to, or what the defendant admitted to, was criminal damaging for backing into this person's bumper. The natural consequence of hitting the bumper is fixing it, right? So you're on a hook for fixing the bumper, but there's nothing about that specific conduct that naturally, inevitably leads to slashed tires and syrup in a gas tank. Right, and that's a similar situation here. There's nothing about being in possession of a stolen car that inevitably leads to the damage that's claimed here.
It sounds like, since we're quoting the first district over and over, that this is unsettled exactly where those parameters are.
Yeah, at least there hasn't been an opportunity for every district to confront this causation issue in receiving stolen property cases. I do think I misspoke earlier when I was talking about the bank robber case. That's Rohrbaugh from the third district that was in the brief, but so we've got the first and third at least. There's, I think, fourth and fifth district case law in the briefs as well. But yeah, I think unsettled is a fine word for it, and I just don't think this, maybe it's just a function of this situation not coming up all that often, and I don't know, maybe that's because trial court's not ordering restitution all that often in receiving stolen property cases.
Or it's an agreed restitution, it's not a go defendant's case or some agreement to restitution, and that's it. Here it in objection.
Exactly, and here we just have the government making different choices, where it didn't make that as part of the agreement, where it pursued only the receiving stolen property charge, and the sum then of those decisions is that this restitution falls outside the narrow path that was available to the trial court here. Thank you, Your Honors.
Thank you. Thank you for your presentation. The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also the opinions are posted on the Ohio Supreme Court website. Thank you.